The evidence that the prosecution have brought before this court on the second accused person relates to the events of 20th of September 2018, and that is the shooting incident. And in that regard, having considered the provisions of Section 129 of the Penal Code of Kenya, and the second accused person having had no objection to her two statements which she gave the police. One, saying that the second accused person, the first accused, was shot in the house, and then retracting that statement the following day. Only leads this court to the provisions of Section 129 of the Penal Code, which states as follows. That Section 128 creates an offense, which is an offense of giving information, false information, to a person employed in public service, and states as follows. Whoever gives to any person employed in public service any information which he knows or believes to be false, intending thereby to cause or knowing it to be likely that he will thereby cause the person employed in public service, A, to do or omit to do something which the person employed in public service ought not to do or omit, if true state of facts respecting which such information is given were known to him, or two, to use lawful power of the person employed in public service to the injury or annoyance of another, is guilty of a misdemeanor and liable to imprisonment for 3 years. The statement which the second accused person gave to the police on 28th was false. The statement was given to a person in public service. The statement intended that that person investigates that offense. That statement was retracted by the second accused person the following day by a different statement now speaking to what is said to be the truth. There is no timelines in criminal law when you can prefer charge against a suspect. The Limitation of Actions Act does not apply to criminal offenses. It is my considered view that the charge brought against the second accused person was not the proper charge. Section 157, sorry, not section, Article 157 gives the power to institute and prosecute a person suspected of committing the offense to the office of the Director of Public Prosecution. And the question posed at this stage is, was there an offense committed when the second accused person gave a statement to the investigating officer at Langata Police Station, which turned out to be not true? I say no more. The office of the Director of Public Prosecution know their mandate. The result is that the prosecution did not adduce adequate evidence for this court to find the second accused person guilty of the offense of murder of Monica Kimani on the night of 19th of September 2018. The first accused person is convicted on the charge. The second accused person is acquitted of the offense. That is the end of the judgment. We move to the next stage. The state you are supposed to go next. So I am expecting the records, if any. Okay. May I know whether Professor Nandwa, you have anything to say? No. The victim's family, Musembi, sorry. Professor Nandwa, yes. Okay. Professor Nandwa, for the first accused person, you have something you want to tell the court?
Your Honor, first of all, we appreciate the effort of this honorable court. This conclusion, we do pray that we be given time also for us to prepare our investigation in favor of this person. We also seek the indulgence of this honorable court that it maintains the bail terms that were granted to the person is not authorized this. We will avail themselves when the mitigation, when required by this report. We also pray that the exhibits that were which are of personal nature, given that the case has been concluded, to be returned to him, and specifically the phones. That's all, Your Honor.
My lady, in the last session we didn't take directions on dressing, so I pray that you excuse me on the dressing that I'm in. Thank you, my lady. The second thing, and which is very important, is to thank you, my lady, for the attention to detail. You clearly gave attention to all the details, both factual, legal, and the issues in between, and we really want you to know that we appreciate as defense your attention to detail. My lady, for the second accused, we want to say, and we wouldn't want to have taken it for granted. We are sorry for the first accused. We are grateful for the acquittal on the charge that she was facing. And we pray, my lady, for release of the securities that had been put in to stand in as her bail.
Are you asking for the release of security?
Yes, we pray for that.
That is surety?
Yes, my lady.
Well, you realize when this matter was going through that process, I wasn't hearing the matter. So what is it that was deposited in court?
We can go to the deputy registrar.
I think it's administrative.
Yes, my lady.
And for me, it should actually just be a natural process, administrative, unless, of course, the state, as I'll be indicating, have a right to appeal.
They do not intend to appeal, my lady.
I do not know where you get that from. I don't know. That I'll leave
Yes,
to you.
my lady.
But of course, if they are not, after 14 days, you can seek for release.
Okay, my lady.
We need to give them the 14 days. Okay.
My lady, that's all we have for the second accused, and thank you very much, my lady.
Okay, so a matter of this nature, you cannot afford to pronounce a sentence without, of course, a pre-bail report, because it is that report that will take into account the views of the victim's family. And so we will start over this matter to another date when we'll be dealing with the sentence. It will also allow the prosecution an opportunity to seek for CRO, those are records, so that the court is guided whether this is the first offense that the first accused person has been found guilty of and convicted of. And it will also allow the first accused person an opportunity to prepare mitigation. And then now need to take a date. We also allow the court assistant we take a date for dealing with the sentence. Diary. It's not my diary. Now, as I had indicated earlier, I'm starting my leave on Monday. I think, Professor Nando, you are aware of that because there are other matters that you have before me. And so, just to guide you, I'll be away from the 12th of February to assistant. You don't have a diary where I can just quickly pick 24 February. 11th of March.